All right, hi there. Welcome to the Chapter 2 video lecture. Chapter 2 focuses in on the trial process itself. The first part of this chapter kind of differentiates between a civil trial and a criminal trial just because they are different. Now, the rules of evidence themselves are fairly similar, but the trials themselves and how they're conducted are pretty different. The biggest and most the biggest difference is the burden of proof. In a civil trial, we have a preponderance of the evidence, which is 50% plus a feather. If you can convince a jury that you were right or you were injured by a margin of 50% plus a feather, then you have succeeded. While in a criminal case, the prosecution must present enough evidence to convict a jury of a defendant's guilt beyond a reasonable doubt. Beyond a reasonable doubt, okay? And different prosecutors define this slightly differently. I've heard prosecutors consider this like a B plus, like so an 80%, 88%. So if you're, pretty confident that this defendant committed this crime, then you should convict. Other prosecutors I've heard argue or define higher, more like a 99% probability this defendant got it. Again, I'm framing this. I'm a former criminal defense attorney, so these are how the prosecutors I've seen and appeared against have defined their burden of proof. So there is a little flexibility as to what it means, but a substantial margin and way higher than 50% for a civil trial. Criminal trials can either be a jury trial or a court or bench trial. This would be a trial just in front of a judge instead of the 12-person jury. The trial doesn't change. And the same rules of evidence apply whether or not it's a jury trial or the bench trial. For a law enforcement officer, one of their main jobs getting ready for trial is to gather the evidence and prepare it for trial. And remember back to last chapter, the chain of custody is a really important part of law enforcement duty. They need to be able to tell the judge or the jury how they took care of the evidence. And they also have to make sure that the prosecutor has enough evidence to fill in the gap between the police officer's standard of probable cause, is it more likely than not this person committed a crime or this place contains evidence of a crime, to the prosecutor's standard of beyond a reasonable doubt. And this is part of why officers will continue to investigate up until or even during the trial. The jury, the Constitution doesn't say that we have to have a 12-person jury. It just says that you have the right to an impartial jury. So states have been kind of left to fill in the blanks on this. In the United States, you are qualified to act as a juror if you are a citizen, you live within the jurisdiction, you're 18, you are able to read and speak English and communicate to other jurors during deliberations. You're in possession of your natural faculties, which kind of sometimes we say sound mind, that you're in possession of your sound mind. Jurors are usually selected from a voter registration list. And then a huge panel, large group comes down, and then of that pool, jurors can be sent to different courtrooms within the House. And once we get down to a pool of jurors who are sent to a courtroom, that group is called the veneer. This is the pool of jurors in the court. As that veneer enters the courtroom, the judge will engage in a general introduction and initial questioning. And then it shifts into voir dire. This means literally to speak the truth, and this is to eliminate someone from the jury who cannot be impartial, because that's a constitutional right. So if a juror is biased or prejudiced against someone because of the facts of the case, the type of the case, pretrial publicity, they are friends with the law enforcement officer or the judge or the police officer, or one of the attorneys, I already said police officer, then that person can be removed by prosecution, the judge, or the defense. And this would be a challenge for cause because there's a reason to remove the person. And then additionally, each side has peremptory challenges, which will let them exclude a juror based on any reason whatsoever. Basically, they just get the sense this juror is not going to be on their side. However, the prosecution nor the defense can exercise their peremptory challenges in a racially or gender-based discriminatory pattern. So you cannot just exclude someone based on their race or their sex, because that violates the 14th Amendment. So once we get to a jury, kind of the goal of that jury is to interpret the evidence that's presented and determine what happened. The ultimate goal is to figure out whether the defendant is guilty beyond a reasonable doubt, and they will ultimately do so by rendering a verdict at the end of the trial. If a jury decides to acquit the defendant for a wrong reason or for no reason at all, there is no remedy for that. And this is called jury nullification. So sometimes this happens because the jury thinks the law is unfair. So if we think about maybe some marijuana cases, it's possible to get a jury that would nullify it because they simply feel that marijuana should be legal. Or maybe someone did something wrong for a good reason, like I did not have this is not my own case, but I know of a case where a nurse would take discarded medications from her place of employment and distribute them to a local needy community. And there was rock solid evidence of videos of her taking it, people testifying of them receiving this medication, which is a crime, but the jury did not convict this nurse probably because they felt like she was doing something wrong, but she was doing it for the right reason to help those in need. So those types of situations, the jury nullifies. There's no other remedy. So the duties of the judge in the trial are to decide what law applies to the case, interpret the law for the jury, decide what evidence is admissible or not, rule on objections, determine the qualifications of witnesses, protect witnesses from overzealous cross-examination, and just in general make sure the trial is proceeding efficiently, effectively. And in most jurisdictions, at the end, the judge will be the one who imposes the sentence. Judges have the power of contempt. They can hold a person in contempt in jail for failure to comply or obey with a judge's order. The prosecutor, meanwhile, they have a duty to prosecute the guilty and see that the innocent are protected. They get to decide what criminal charges should be prosecuted, what should be dismissed. They have this is a really broad power that the prosecutor is invested with. Prosecutors, when they decide these things and when they're deciding what evidence to use, will consider their past experience with a particular charge, their knowledge of the judge, how much information has to be given to the defense, and whether or not that information makes it less likely for the prosecutor to win. And the prosecutor, as part of this, they're trying to meet the standard of reasonable doubt, beyond a reasonable doubt. There is not, and they have to meet it for each and every element of the case. There's not a specific set of words or phrasing that is required to be used when instructing the jury, which is why a few slides back I said that different prosecutors define it different ways. But reasonable doubt is a reason that would make a reasonable person hesitate to act in connection with an important decision in life. So the primary jobs of the defense attorney are to represent your client zealously, and to make sure that all the constitutional standards were met, probable cause exists, did anything violate their right against search and seizures. As part of that, defense attorneys need to prepare for pretrial investigations and discovery. You need to talk to your clients about not making what types of statements and how to deliver certain statements. Like, should they be talking to the police without you there? Probably not. And then during the trial, the defense attorney should cross-examine all witnesses. We can kind of boil this down to the job is to ensure that the defendant gets a fair trial and that you zealously represent the accused. Okay, so we're going to stop this video here, and I'm going to post a second follow-up video that just deals with the trial process. So if you have any questions about the trial process, we're going to be covering things like opening statements, closing statements, and cross-direct examinations.